Welcome to the debrief, everybody. The criminal case against Parkland school shooting suspect Nikolas Cruz is moving forward. Defense attorneys for Cruz are asking a judge two things, and each request was the subject of a different hearing today. First, the defense wanted the judge to dismiss a charge of attempted battery against a law enforcement officer in jail. The defense says that charge isn't even in the statutes in Florida. However, before the hearings began, the judge spoke to Cruz about waiving his appearance in court.
How old are you?
21.
And how far did you get in school?
12th grade.
You completed 12th grade?
No.
Okay, but you got partially through 12th grade?
Yeah.
And have you had the opportunity to discuss this motion to dismiss on your pending case that relates to charges or acts that were allegedly committed in the Broward County Jail?
Yeah.
And do you understand what this motion is about?
Yes.
Do you understand that if I grant this motion, your charges could conceivably be dismissed, or they would be if I were to grant the motion?
Okay.
Do you understand that?
Yeah,
do you understand how that may or may not affect you in the future, or how that may or may not affect your other case?
Yes.
And have you gone over the motion in depth with your attorney?
Yes.
And do you understand that if you don't agree with my ruling, and let's say you were convicted in this case, you can't go back and claim that your counsel was ineffective by allowing you to excuse your appearance at a later date? Do you understand that?
Yes, I understand.
Are you making this decision of your own free will?
Yes.
Okay, I'm going to find that the defendant is making a knowing, intelligent, and voluntary waiver of his right to be excused at the motion to dismiss this morning.
Cruz seems to want to waive his right to be present at all pretrial hearings, but for the reasons you just heard, the judge said she's going to take the request on a case-by-case basis. She doesn't want issues down the road. Now, the new charges against Cruz relate to a jailhouse incident last year. Here's the state's version of it. A guard told Cruz to stop dragging his sandals, so Cruz gave the guard the middle finger, rushed the guard, shoved him to the ground, and punched him in the head. Cruz grabbed the guard's stun gun and discharged it. The guard wrestled the gun back and hit Cruz in the face. Here's the defense, the state, and the judge's response to a motion.
The reason why attempted aggravated battery on a law enforcement officer is not a criminal offense is because the statute 784.07 lists the qualifying offenses, the eligible offenses that are subject to reclassification. It only lists 4 of them, and those are battery, aggravated assault, and simple assault.
When you look at robbery and you look at a lot of other offenses, they don't say an attempt is also applicable. You just apply 7704, and that's the same thing that we're saying here. 78407 creates the crimes, separate crime, not just aggravated battery, because we have another statute that has aggravated battery and doesn't say, oh, and an attempt of an aggravated battery is also a crime. That's a perfect example. It just says aggravated battery is a crime, and then you can apply 7704, and it's an attempted aggravated battery.
I am going to take the matter under advisement, and I should have a written order for you in the next few days.
We will wait for that ruling. At a second hearing later on today, the judge examined the charges against Cruz, which related to the actual Parkland school shooting. One issue surrounded the state's intent to seek the death penalty. Florida prosecutors must file a document, a notice of intent, within 45 days of arraignment. Here, the state did that, but did not include the names of the 17 victims. The state filed a new document, this is the new one, with the names, but it didn't have the word amended on the top. The defense, therefore, says it's invalid because of the time frame, and the state tried to clarify its position.
They're the same pleadings, putting the defense on notice of the same crimes, the same intent, the same aggravators, which were 7. The only difference is that it listed the victims, and the defendant knew, by virtue of the media, by virtue of arraignment, by virtue of indictment, he knew, it was already out in the press, who the victims were. So there's no surprise, there's no prejudice, there's no reason to seek the extraordinary remedy that the defense is seeking in this case, which would be to prohibit the state from seeking the death penalty, where this defendant murdered 17 people. Now, for the other part of their argument, where they allege that they need They didn't know that the state was seeking the death penalty on any of these crimes or which ones. Let there be no mistake that the state is seeking the death penalty against this defendant for each and every of the 17 murders that is alleged in the indictment. Every one of them, Your Honor, so that there's no mistake and no confusion. Every one of them.
The defense also argued against the so-called laundry list of aggravators the state put in its notice to seek the death penalty. The defense said not all of the factors even apply to this case.
They file a notice that doesn't state which counts, if any, or which counts they're seeking death on, only that they are seeking death. And they file this laundry list of 7 aggravators that clearly they do not have a good faith reason to believe they can prove with respect to each and every count charged or capital count charged in the indictment. For example, the victim of the capital felony was an elected or appointed official engaged in the performance of his official duties. Even for the sake of argument, if they can say if that applies to the faculty, that certainly doesn't apply to students. So this notice, which the rule requires and the statute requires them to give us, I mean, there's no point in giving us notice if you're going to just throw aggravators in and not say which counts and not say which counts they apply to. That's tantamount to no notice. A defendant is entitled to separate verdicts on each count and separate verdicts as to a sentence of death or life as to each count. And so that in and of itself requires the state in its notice to say which counts they're seeking the death penalty on and which counts they're seeking or what aggravators they're seeking it based on.
The judge did not rule on those arguments right away either. We're going to wait the ruling on that. Here tonight, attorney Michael Bryant, criminal defense attorney Ecleynne Mercy. So Ecleynne, one of the defense's big complaints here is that the state seems to be cutting and pasting the aggravators into the notice to seek the death penalty, and the defense doesn't like that here. Do you think it's really a bad tactic for the state to do that?
Yes, it is. The case is too big. This is not the case that you want to play. This is not the case that you want to cut corners on. Like even, I mean, I know for the lay person, a word like amended doesn't seem important. But if you're practicing law and you're looking at 17 murder victims, the word amended should be there. You shouldn't have a motion. You shouldn't have a response. You should not have a notice in which countless attorneys reviewed. And that was a mistake on the state side. And then you have defense who is using that. Like, listen, they can possibly just have new case law when seeking the death penalty to provide the aggravating factors so that the defense has, you know, can put that and have notice of that when they're arguing their case, you know, in chief. So I think that the state kind of dropped the ball with that.
Okay, but a lot of people just look Michael Bryant and say this is all semantics, it's minor arguments, it's one little word, you know, and I think that's what the state's going to try to rest on here.
Yeah, yes, Ecleynne. I mean, really, it becomes a matter of form over substance. Let's look at it. The reason for the notice is to do just that, give notice to the other side, the defense in this case, that the death penalty is being sought. Was there anybody on the planet that didn't know they'd be seeking the death penalty in this case where 17 innocent people were killed? Of course not. So the notice was less important than it might be in a far less different case.
Yeah, Ecleynne, I'm going to ask you this one here. It did seem a little bit strange to me that the state was saying, well, he knew who we were charging him with killing because the names were in the press. I didn't realize that people like me played any kind of statutory or legal function in giving a defendant notice on who he's accused of killing.
Exactly. And, you know, we don't know. And you're leaving it. He's in jail. How is he going to watch these things? He's not taking notes. And at one point he was in a hospital gown. So you're just assuming a lot. So that notice that needs to be provided needs to be provided. He needs to know, well, just like how he needs to know the importance of him not being at the motion, he needs to know exactly what aggravated factors is. He had an AR-15 and he just sprayed. He didn't spray and then figure out, okay, I did this person, this person, this person.
Well, that's what the state's basically asking him to do here. Look, it seems to me that what's going on here is the defense is trying to delay a little bit because the defense has complained in other hearings that it hasn't had enough time to go through the discovery. The state is upset about that. This might be what's behind this. We're going to move on, though, now to several other cases we are watching. Actor Cuba Gooding Jr. is facing new charges in a third alleged sexual misconduct incident. In the latest case, the actor is accused of forcibly touching a woman at a New York nightclub in September 2018. He's already facing 2 separate allegations of groping women in bars. Gooding pleaded not guilty to the new charge. Prosecutors accused the defense of leaking surveillance video showing the actor and the first accuser leaving the nightclub. In another apparent leak in the case, a New York Police Department detective is accused of releasing the actor's mugshot 2 days after his arrest in June. This week, the detective was stripped of his badge and gun and placed on administrative duty. Actress Lori Loughlin and her fashion designer husband are pleading not guilty to a new charge in a college admissions cheating scandal. Federal prosecutors slapped Loughlin and others with a charge of federal programs bribery in a likely attempt to spur a guilty plea. Loughlin and her husband face a maximum of 20 years behind bars if convicted. New details now in the case of a murdered 4-year-old Houston girl. A grand jury has indicted Maleah Davis' stepfather on charges of injuring a child. Darian Vance is accused of hitting the little girl with his hand and with a blunt object. He's also accused of restricting Davis' airway with an unknown object. Vance originally told police a group of men kidnapped the 4-year-old girl and beat him. A month later, investigators found Davis's remains in a trash bag in Arkansas. Vance is scheduled to be arraigned on November 12th. Activists are renewing a call for federal charges to be filed against a former Chicago police officer convicted of murdering LaQuan McDonald. Activist William Calloway and NAACP members are petitioning the U.S. Attorney for the Northern District of Illinois to file civil rights charges in the case. Calloway spearheaded the call for the release of police video seen here of Van Dyke shooting and killing McDonald. Van Dyke is currently serving a 7-year state sentence. And still ahead tonight here on The Debrief, sentencing next week for a young Tennessee man who pleaded guilty to avoid a second trial after he says he shot the man who was attacking his girlfriend in self-defense. And opening statements in the retrial of former NFL player Kellen Winslow II are set for Monday after a jury selection process that seemed to go on forever. That and other cases when we return. Welcome back to The Debrief. Sentencing next week for the young Tennessee man who pleaded guilty to killing an older man who he said had molested his girlfriend. Court documents say 25-year-old Sean Foley faces a 3 to 6 year sentence for shooting and killing 44-year-old Jimmy Shelton. Foley said he pulled the trigger in self-defense after confronting Shelton during a sexual incident with the girlfriend. Foley said Shelton attacked him, so he fired. Foley recorded the confrontation and the aftermath.
All that's on recording is recording right now. I swear to God, you sick. You with her again, and I will drop you.
Sean, stop.
No, that's watch your fucking stop. That's too much. No, that's too much. You over there. Come here. Come here now. He was molesting her. I have it all on recording.
Did you shoot him?
Yes, he was molesting her.
Here's how the defendant characterized what happened from the witness stand.
When I went out the door, he pushed her off of him, and she pulled her pants up and said, "Baby," and ran to me. And when she was running to me, he shifted his weight. He kicked his right leg out, and he leaned back in the chair, and he put his hand into his pocket, and I thought he was drawing a gun on me.
Did you ever see a gun? Did you ever see him with a gun?
With a gun, yes. This night specifically.
Yes. Did he have a gun right then?
He didn't get out before I drew mine.
Okay.
I was concealed, and when he did that, I just drew mine. I told him that if he touched her again, that I was going to drop him. I looked up, and he was in front of me, and he was running at me, and he had his hand out. And And then he grabbed the top of my weapon. And, I don't know how he got to me so fast. But, it went off. And, I just remember pushing her right backwards and trying to jump on top of her. And I don't know.
The girlfriend testified several times during the trial. She ultimately said that some of her sex acts with the victim were abusive, while others were consensual. Prosecutors also asked her whether the victim did indeed attack the defendant.
Can you tell us about what happened when Sean walked out?
I pulled my pants up and Jimmy stood up, and that's when Sean started yelling at Jimmy. He told Jimmy to stop touching me.
Was Jimmy touching you when he came out?
I think he had his hand on my leg, but I don't really remember.
Did you ask Sean for help?
No.
Did you call for help?
No.
Did you scream for help?
No.
Did you need help from the defendant that night?
No.
Is the contact between you and Jimmy Shelton consensual that night?
Yes.
Was that meant to be the contact that was going to get you the car?
Yes.
How much is the car worth?
I don't know. We hadn't furthered any discussion.
Do you know what kind of car it was going to be?
No.
Do you know if he had made any arrangements to get you the car already?
I found out later, yes.
Did Jimmy ever tackle Sean?
I didn't see it happen.
Okay. What caused the defendant to shoot Jimmy Shelton?
I'm not sure.
The jury acquitted the defendant of first-degree murder and was deadlocked as to the next lesser charge. Foley ultimately pleaded to voluntary manslaughter. I'd like everybody's opinion on the sentencing range here. Ecleynne, you start. Seems to me that he's getting a pretty decent deal here.
Yeah, I would definitely give him that deal. You have the testimony of Miranda, who it just doesn't make sense. She was emotionless. She basically confirmed Sean's story, because it started off with, I was pulling my pants up. You're not pulling your pants up if you didn't pull them down in the first place. So what he thought actually happened probably did happen, because he saw. So it goes along with his story. And I feel like, it just didn't look good to have her so just calm and just out of it and just dejected. And vice versa from Sean, who was just emotional and just couldn't hold it together, even when she was testifying.
Yeah, Michael, Bryant here. This guy goes from first-degree murder down to voluntary manslaughter with a range of 3 to 6.
Great deal. I mean, the defense should be getting a raise for this. I'm sure the prosecution said, okay, here we go. We have the most sympathetic is the defendant. We have the second most sympathetic, Miranda, and the least sympathetic, the victim, Mr. Shelton. That's a bad combination for any trial, let alone a retrial.
Yeah, one has to wonder if the prosecutor was sort of overreaching with the first-degree premeditated murder charge in the first place here. But we'll wait and see what the sentence is when that case picks up next week. Opening statements are scheduled Monday afternoon Eastern Time in the retrial of Kellen Winslow II. 5 women accused the former NFL player of a series of sex crimes. A jury convicted Winslow last summer on 3 counts and acquitted on 1 count. The jury was deadlocked on 8 other counts. Prosecutors are trying once again for a conviction on those 8 counts. And a correction to information we brought you yesterday. Prosecutors are indeed moving forward with charges of cruelty and battery against an elder. Those charges are simply being severed from the upcoming retrial. Both of the counts that we're talking about here resulted from the testimony of so-called Jane Doe number 5, a 77-year-old woman whose hands we see here. When she testified, she accused Winslow of lewd conduct at a health club. A jury hearing opening statements in the trial of a Colorado man accused of killing his fiancée last year. Patrick Frazee is accused of beating his fiancée, Kelsey Barrett, to death with a baseball bat. Authorities say he asked Crystal Lee Kenny to clean up the aftermath. Kenny said she was in a side relationship with Frazee. Barrett disappeared after this surveillance footage released by authorities showed her out grocery shopping with her baby around Thanksgiving. We cannot broadcast the trial or tweet from court under the judge's orders. The judge is even banning a sketch artist from the courtroom. 7 women and 5 men are on the jury. 4 other people are alternates. Let's jump back in with the panel now. Ecleynne Mercy, Michael Bryant. So, Ecleynne, interesting discussion coming out of Cripple Creek, Colorado there. Judge saying, well, the courtroom's too old to handle the press. There's some good reporting coming out of the newspaper in Denver saying this is an old facility. It's about 100 years old. The floors squeak. The chairs are original to the building for the gallery, and they've got racks on the bottom where people used to put their cowboy hats and everything. But there's sort of an interesting comment in this article I read that basically said, a local politician said, you know, this is a tourist town. We function on casinos. We don't want people thinking this is unsafe here. How is an accusation that a fiance murdered a fiance suggests that tourists are unsafe in this little tourist town in Colorado?
I think that is crap. I think that the argument is crap. I think that what happened was you had a judge who probably saw the Amber Geiger trial, didn't want the same smoke on them, and is just finding out arguments not to have a public trial. Now, with regards to your courtroom being 100 years old, at that point you should blame your politicians on why this, renovations haven't been done.
Yeah,
so
the technology changes too, Ecleynne and Michael. Like our transmitters are like this big that beam these cases everywhere. We don't need this big, huge corner of a facility here. And one thing that local officials were complaining, saying, oh my gosh, we've gotten calls from people in other states that want to come here and watch this. Well, that's why many states let cameras into court so that people can watch the proceedings.
That's exactly the philosophy. You want to open it to the public to the degree you can. If the physical structure won't allow it, hey, how about TV? No sketch artist? Come on. Maybe I can get in there with some sort of mental telepathist who can kind of send me some.
You can figure out what it's going to look
images,
like. Ecleynne, is this no sketch artist thing going to result in a First Amendment prelocutory appeal or something like that?
If I was defense, I am putting that in the chamber. You can tell they just don't want you there. They don't want it aired out. They don't want, their mistakes in the state's office.
Bingo.
Yeah.
Paperwork wasn't filed on time to go after what, Michael? This, that, the other thing?
Everything.
Yeah.
Everything. They've been so delayed in everything they should have done. It's like, who wants a spotlight shined on that kind of bad news?
Well, serious things happen in small communities and big communities, and people want to know, is justice being served? And that's why we show up to so many of these cases. We're going to keep an eye on it as best we can, as I've been saying all along, once we get a little bit more out of the courtroom, but it's going to take a lot of legwork because people have to listen, run outside, and basically spill what they heard. Michael, Ecleynne, great to have you on the broadcast tonight. We're going to wrap things up. Live trial coverage resumes on the Law and Crime Network Monday at 9 a.m. Eastern. We'll be back here on the Debrief at 5 o'clock. See you then, everybody.